Patricia Van Haren, family law attorney. What happens if I can't get my former spouse to agree to have our child in therapy? When parties share joint legal custody, both parents must agree to mental health counseling for the minor children. They must cooperate and come to an agreement on who the therapist will be, how often the child will be in therapy, and who will pay for this therapy. Sometimes parents can't come to an agreement as to whether the child should even be in therapy. One parent may be concerned about the behaviors of the child that they are noticing, or behaviors that have been reported by teachers at school. Or they may simply seek that the child have an outlet to deal with the issues in regards to the new custody in place after the divorce, or just to have a safe space to talk. In a perfect world, both parents will agree as to what is in the best interest of the child. However, in cases where the parents are not able to come to an agreement, in order for the child to be able to attend therapy, one of the parents may need to file a request for order with the court in order to obtain orders for therapy or possibly sole authority over mental health decisions. In cases like this, the court may choose to appoint an attorney on behalf of the minor child. This attorney would be able to speak to medical providers such as a child's pediatrician, both parents, the minor child, and the school teachers of the child. If minors counsel determines that it is in the best interest of the child to receive therapy, then the court may order to let the child to participate in that therapy. There are some cases where the child is having problems in school, and the school recommends that the child see a therapist. Because both parents hold the educational rights over the child, they must come to an agreement if those services are offered by the school. If one of the parents is not in agreement, the other parent may have to seek court intervention in order to comply with the recommendations of the school district and the educators of that child. It is important to first try to resolve this issue between the parents. We recommend to our clients that they do so through email so that they may establish evidence for their case in the event that there is no agreement. In some cases, the child may have an IEP, and recommendations may be placed in that IEP for counseling. If a parent does not agree, then it may be in the best interest of the child for the court to place final decision-making powers with the parent who is able to follow the IEP. We had a case come up where the minor child was exhibiting extreme depression and self-harming behaviors. The mother continued to deny that anything was wrong with the child and refused to cooperate with the father in obtaining therapy for the child. We brought the issue in front of the courts on a request for order to appoint minors counsel to determine whether therapy was appropriate. Minors counsel presented evidence that it was necessary for the child to attend therapy. It was also found that mother's new boyfriend was abusing the child, and this came out in the therapy session. Our client was able to obtain custody of the minor child based on that information, and the minor child has continued in therapy and is no longer presenting these behaviors. If you have any questions or you want any more information about whether you can obtain therapy for your child, shoot us over an email or give us a call.